students, welcome to Legal Learning. So today I'm going to discuss or deal with this question. Okay, this question is about discuss the various legislative functions exercised by the President of India. Legislative function of President. Write an exhaustive note on power to make ordinance. As we know, Article 123, 1, 2 and 3. This is the Article 1, 2, 3 deals with the President's power to make ordinance, right? So let's begin. So the legislative power can be discussed under following 1, 2, 3, and 4. So 1, 2, 3 and 4. These 4 heads. The first one is participation of the executive in the legislative process. As we know, there are 3 organs of the government: executive, legislative and judiciary. So President is the head of the Union Executive. Article 52, there shall be a President of India. Article 53, President shall be the head of the Union Executive, right? So Article 53 is important in this regard. Then also under Article 74, we find that the Council of Ministers, and the 75 deals with Council of Ministers. 74 says that the President shall act on the advice of Council of Ministers. So there is a concept called separation of judiciary, right? Separation of powers. That means the organs of the government like executive, judiciary and legislative, they are kept separate for the purpose of proper functionings of the organs of the government. But when we see the executive and legislative, executive is the residuary of legislative powers, right? There are connection between executive, just like President and Council of Ministers. The Prime Minister shall be the head of the Council of Ministers, and the President shall act on the advice of the Council of Ministers. And Council of Ministers shall be collectively responsible to the House of the People, that is Lok Sabha. So collective responsibility, this is what is called. So that means there is no complete separation between executive and legislative. There is some relation, right? So that's why for example, the President under Article 1, the President gives assent to the bills. Without giving assent to a bill cannot be passed, right? President's assent is important. So that's how President participates in the legislative process, right? Then comes power of rule making under the Constitution. These powers are also there under and also there is President shall summon the houses, summon, prorogue and dissolution of House of the People. So these provisions are there under probably 84 of Constitution of India. And also third one is power to proclaim an emergency. We know that 352 to 356, these articles deals with provisions relating to emergency. 352 national emergency. National emergency can be on 3 grounds: armed war, external aggression and armed rebellion, right? Then 356 is relating to state emergency, that is on the ground of failure of constitutional machinery in the state. And 360 is financial emergency. And one important thing that is important for MCQ is that financial emergency has never been invoked, or never been proclaimed in India, never been proclaimed. Okay, this 360 was never used. Okay, many times there was national emergency during the ruling of Indira Gandhi, of course. And the third one is power to make ordinance. We know the President as well as the Governor has the power to make ordinance. President has power to make ordinance under 123, right? Okay, another important thing I'm going to point out here. The Council of Ministers be integral part of Parliament participation. Okay, so Parliament. What is the composition of Parliament? So the Parliament shall be composed of 3 elements, 3 organs. One is President, another is Lok Sabha, that is the lower house, House of the People also called, and Rajya Sabha, that is the upper house. Done. Lok Sabha, the term of Lok Sabha is 5 years. Done. It is subject to dissolution, but the Rajya Sabha is not subject to dissolution, and 1/3, I think 2/3 or 1/3, I forget it, of its members retire in every 2 years. Done. So the President of the Parliament composed of President, Lok Sabha and Rajya Sabha. That means President is part of the Parliament. Done. This concept is underlined by the making President a component part of Parliament. Okay. Okay, and another thing you can see here. The executive power to convene and prorogue Parliament. The President has power to prorogue Parliament, dissolve Parliament, summon the two houses, and can and for the joint meeting also the President can summon the two houses, right? So this prorogation, summon, and dissolution, these things are important, right? That's how President participates. Presentation of bills to Parliament and the requirement of President's amend for transforming President's assent. 111 Article 111 deals with the assent of the President. When President will sign in the bill will become act. When the act it will become act, it can be enforced, right? It is enforceable. So bill and act done. Assent of the President is required for transforming a bill passed by the two houses into an act. Are some of the indicia which denote the intimate role played by the executive in the relations to the legislative process. Done. So there are also several provisions which requires the recommendation of the President. Done. Let's see what are those provisions in the Constitution. Introduce in either house a bill for the formation of new states or alteration of areas and boundaries or names of existing states. So here I am going to mention Article 3. Article 3 deals with formation of new states, alteration of areas or boundaries, alteration of two things. One is area and other is boundary, AB. Alteration of AB and also name. Area, boundary, and name of existing states. Done. For this purpose, recommendation of President is required under Article 3 deals with certain provisions. Clauses A, B, C, D. Their provision is also there. If you go to the Act, you can see here the President's recommendation is required. So read Article 3, you will get there. Money bill cannot be introduced without the recommendation of President. This is very much important in regard to the money bill. Money bill is different from ordinary bill. There are three kinds of bill. One is ordinary bill, another is financial bill, and the third one is money bill. So this is the circle. This is the circle. This is financial bill, and here this circle represents money bill. Done. So this point is important, and President's recommendation is required for consideration by a house of a bill involving expenditure from the Consolidated Fund of India. We have funds like Consolidated Funds of India, and Contingency Funds of India. So these are expenditure. So in this case also the President's recommendation is required, and in other cases prior recommendation by the President is required for introducing in either House of Parliament any bill affecting any tax in which states are interested. So in case of taxation, like affecting any tax, any bill that affects any tax that deals with the matter relating to taxation, and first requirement is taxation, and the second it which affects the state. In that case the prior recommendation of Presidents are required. Then comes the rule making power. Central rule making power. Constitution provision confer rule making power on the central executive. The rule making power is in the hands of the central executive. There are two kinds of executive: state executive and central executive. Done. Enabling it to prescribe detailed provisions for the several matters. For example, what are those matters we need to see? Authentication of orders and instruments. Authentication. This is very important. There is a section, I think 86, I forget the section. Authentication of orders and instruments made and executed in the name of the President. Every instruments shall be made and executed in the name of the President. The mere convenient transaction of government's business. For government's business, authentication and execution of bills and instruments. Then government business. Then C, consideration of services, etc., of audit and accounts departments, chairmen and members of the union and the joint public service commissions, secretariat and staff of houses of Parliament. Done. What are the points here? Condition of service. It's about mainly condition of service. It's about mainly condition of service of what? Etc. of audit and accounts. Audit and accounts. A2. Audit and account department, chairman and members of the union, and chairman plus members of the union and joint public service commissions, secretariat and staff of the House of Parliament, staff of HOP, House of Parliament. Done. Consultation with the UPSC regarding appointment of officials of the Supreme Court, Okay, dual membership of parliament and state legislature. Procedure to be followed in the joint sitting of the two houses of parliament. These are some rule-making powers relating to procedures, condition of service, etc. Regulating the requirements and condition of service of person appointed to services and parts in connection with the affairs of the union. Affairs of the union, that's why president has the rule-making power. Then comes the declaration of emergency. As I have already told that Article 352 to 360 deals with emergency, and during the declaration of emergency, proclamation of emergency, then the president has power, right? Then ordinance making power. This is very important and we all know about it, right? The central executive has power to issue ordinance and promulgate laws for a short duration. Why ordinance making power is required? When there are two houses, there are sessions of parliament, when sessions of Lok Sabha, when the Lok Sabha. So in case of emergency, when there's, I'm pointing here, extraordinary situation which demands immediate action, inaction of laws. So in that case, the president has the legislative power to promulgate ordinance, and the ordinance is temporary law. And here it is important that the executive in the Britain enjoys no such power. Done. So this is the only the president enjoys the power. Ordinance making 1, 2, 3. Okay. If you read 1 to 3, president to promulgate such ordinances, the circumstances appear to him to recur when both the houses of parliament are not in session. Both the houses means Lok Sabha and Rajya Sabha, these two houses are not in session, and he is satisfied that the circumstances exist which render it necessary for him to take immediate action. That means there is some kind of emergency. Immediate action is required. Done. The provisions confers the power formally on the president, but as already stated, he acts on this matter as he does in other matter on the advice of the Council of Ministers. As I have already mentioned, Article 74, 75, 74 mainly. So president acts on the advice of the Council of Ministers. So therefore the ordinance making power is vested effectively in the central executive. Done. So there's R.C. Cooper. This is very leading case. Okay, R.C. Cooper versus Union of India. This is leading case. We need to read leading cases. This is very important. So what has said that the ordinance is promulgated in the name of president and in a constitutional sense on his satisfaction. Constitutional sense on his satisfaction. It is in truth promulgated on the advice of the Council of Ministers, because of course president acts on the advice of the Council of Ministers and on their satisfaction. So practically this is on the advice of the Council of Ministers. Although it shows that it is the president's promulgates the ordinance, but practically because president acts on the advice of the Council of Ministers, president is merely the nominal head. The real executive power vested in the Prime Minister, PM, who acts on the advice of the who is the head of the Council of Ministers, and president acts on the advice of the Council of Ministers. So that's why Council of Ministers are made. That means Prime Minister practically. The power to issue an ordinance is legislative power, obviously, because it is something when the both houses are not in session and the situation demands immediate action. In those cases, the ordinance can be promulgated. An ordinance issued by the president partakes fully of the legislative character and is made in the exercise of legislative power. Section 72 of the Government of India Act 1935 authorized the Governor General to make and promulgate ordinance for the peace and good governance of the British India in case of emergency. So it is relating to British India. And we know that most of our constitutional provision has been derived from this legislation, Government of India Act 1935, right? So section 72 of the Act was also similar. So in British era also we find similar provisions. Done. An ordinance cannot be promulgated when both houses of parliament are in session. Article 123, clause 1. This makes sense because that time the Lok Sabha can make bills, right? Accordingly, ordinance make when the two houses are in session is void. Okay, so this is important because both houses are in session. So why there is need of ordinance even? They can pass bill. It may, however, be made when only one house is in session. The reason being that a law can be passed by both houses. Yeah, both houses, Rajya Sabha and Lok Sabha, and not by one house alone, and thus it cannot meet a situation calling for immediate legislation. And recourse to the ordinance making power becomes necessary. So because a law must be passed by Rajya Sabha and Lok Sabha, that it must receive the assent of the president, 3 stages, right? Then it will become from bill to act. So if there are one house that is in session, that case also ordinance can be made. But if the 2 houses are in session, in this case it become void. So this is what basically saying. However, it is to be noted that the ordinance making power is not unrestricted. That means it is not absolute. An ordinance can remain in force only for a short duration. That's why it is called temporary law, and is brought under the parliamentary scrutiny. The parliament will again scrutinize it at the earliest possible opportunity. The scheme of Article 123 is to place the ordinance making power subject to the control of the parliament. Of course, there is a parliamentary control, meaning the Lok Sabha control, obviously, rather than that of the courts. Yeah, because it is legislative power, so the courts rarely interferes, right? When we know that there is the power of judicial review of the courts, right? It is possible only in cases when an act is beyond the power of the constitution. That means it is ultra vires, void, okay? Only in that cases. Okay. The ordinance shall cease to operate at the expiry of 6 weeks. This is very important. You just need to remember this figure. This if you are preparing for judicial service, then these are MCQ kind of questions, okay? So these are very important. These figures are very important. 6 weeks. C, W, done. O, ordinance 1, 2, 3, 6 weeks. Okay. From the Assembly of Parliament. When the 2 houses of Parliament assemble on different dates, the period of 6 weeks reckoned from the later of the 2 dates. Later, the last one, I mean. It means that the Parliament must pass a law to replace the ordinance. So that's why passing of law is important to replace the ordinance within 6 weeks of its assembly. There are many laws that Parliament makes. Okay, thus the maximum duration for which an ordinance may last is this part is important. If the executive misuses or abuses its power, the House of Parliament may not only disapprove the ordinance but may also pass a vote of no confidence against a Council of Ministers. So this is important. An ordinance has same force and effect as an act of Parliament. Obviously, an ordinance come to an end in the following situations. These situations are important. When resolution disapproving the ordinance are resolution, the Parliament shall pass the resolution disapproving the ordinance are passed by both houses of Parliament, and it shall be passed by both houses. That means Lok Sabha and Rajya Sabha. There must be a resolution. The resolution must disapprove the ordinance, and it shall be passed by both houses of Parliament, that is Rajya Sabha and Lok Sabha. If the ordinance is not replaced by an act within the stipulated period, so it should be replaced by an act. The executive, if it is not replaced, then obviously it ceases. The executive lets it lapse without bringing it before the House of Parliament. Yes, because it is subject to the scrutiny of the House of Parliament, right? It is if it is withdrawn by the government at any time. Done. An ordinance can make provisions with respect to matters in list 1 and list 3, but not in list 2, because list 2 is state. As we know that there are 7 schedule. There is 7 schedule of the Constitution of India. In 7 schedule there are 3 lists: list 1, list 2, and list 3. Union list, state list, and concurrent list. And also 246. Article 246 also very important. It provides the power of Parliament, state legislature, and both Parliament and state legislature to enact make laws in list 1, list 2, and list 3, which is concurrent list. Okay. There are 97 subjects, 66 and 40. If I get the figure. Okay, an ordinance can make provisions with respect to a matter in list 1 and list 3 and not in list 2. Now, because list 2 is the state list, okay? So, list 2 is the state list, except when a proclamation of emergency is in operation. State emergency, obviously. 3. A very important thing, ordinance is also just like law. An ordinance is also subject to fundamental rights. What is law? Article 13 describes what is law, right? And law, yes, Article 13 is important. It provides the power of judicial review as well. And just like because in ordinance is also a law. obviously, so it is subjected to fundamental right. It cannot take away or abrogate the rights conferred by Part 3 of the Constitution of India, that is fundamental rights. Done. Then A.K. Roy versus Union of India, the Supreme Court has emphasized that an ordinance is a law and is a product of exercise of legislative power. It is a law for the purpose of Article 21 as well. The court has rejected the contention is R.K. Garg versus Union of India. So for suppose A.K. Roy and R.K. Garg, we need to read these two cases together. Union of India and R.K. Garg versus Union of India. Then under Article 123, President has no power to issue an ordinance amending or altering the tax laws. An ordinance has the same force and effect as an act of parliament. There is no quantitative or qualitative difference between an ordinance and an act passed by parliament. President, the power is coextensive with the parliament power to make laws. Done. Okay. There is important. This is an ordinance was promulgated by the president in 1996, declaring a section of the population of Assam as scheduled tribes. Okay, ST. The same ordinance was repealed several times and ultimately it lapsed without Parliament passing an analogous act. There was no legislation, the Parliament didn't pass any act, and it was what happened. It was lapsed. Done. The High Court in Guwahati ruled in Maitreya Mahanta versus State of Assam that as Parliament did not pass the necessary law, the ordinance should lapse, and accordingly the rights vested in the communities by the ordinance should also lapse. So that's all. Thank you. Thanks for watching. This was the question number 3. First question was constitutionalism and what is constitution. The second question was judicial review. This is comparative public law. So this was question number 3 relating to the legislative power of the president. So this was note. So this is very important. Just kind of you can take it as a model answer. Okay, you can modify your answer. You can add provisions and you can add articles in your answer. You can browse the Bare Act and see what are the articles, and you can add it. So you can add case laws as well. So thank you. Thanks for watching, and please do not forget to share, subscribe, comment, like. Okay, thank you.